Let us pay attention and listen to this very important immigration news that is affecting families, workers, students, and visa applicants around the world. Over the past couple of weeks, immigration news across YouTube and social media has been filled with alarming headlines about a so-called new visa ban, sudden travel blocks, and claims that green card holders may no longer be safe to travel in 2026. Some videos suggest immigration has been frozen entirely across the board. Others say visas are being canceled overnight without any warning or due process. And for many families who depend on accurate information to make critical life decisions, this flood of conflicting information has created confusion, fear, and deep uncertainty about what is actually happening in the U.S. immigration system. That is exactly why this video is necessary, and why we are taking the time to address these concerns in a comprehensive and balanced manner. When immigration policy shifts, misinformation spreads quickly through social media platforms, messaging apps, and community networks where people share information without always verifying its accuracy. Not all headlines reflect the full or accurate picture, and partial information can be just as harmful as completely false information when families are trying to make decisions about travel, applications, and their futures. So instead of speculation or panic, what matters right now is clarity, accuracy, and a calm understanding of what the policies actually say and who they affect. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now, let us get into the video. Welcome to U.S. Immigration Info, your trusted source for accurate, verified, and timely immigration information. In this video, we are going to separate facts from rumors so you can understand what is actually happening versus what is being exaggerated or misrepresented online. We will explain what the Trump administration has actually ordered regarding visa bans and travel rules in 2026, based on official proclamations and policy documents rather than speculation. We will clarify how these policies affect green card holders and visa holders in various categories and circumstances. And we will help you understand what is correct information and what is not, before you make any decisions that could affect your immigration status, your travel plans, or your family's future in the United States. To understand the current situation properly and avoid the confusion that has spread through immigrant communities, we need to start with the expanded travel ban that took effect on January 1st, 2026. In December 2025, the administration issued a presidential proclamation that builds on prior travel restrictions by expanding the list of countries whose nationals face restrictions on entry and visa issuance. This new ban was designed to restrict travel from several dozen countries based on national security and public safety criteria that the administration has identified as priorities for enhanced screening and vetting procedures. Under this expanded ban, foreign nationals from designated countries who are outside the United States on January 1st, 2026, and do not hold a valid U.S. visa on that date are subject to restrictions on entry and, in some cases, on visa issuance. This is a critical distinction that many alarming videos and social media posts have failed to make clear. The restrictions primarily target people who do not already have valid documentation, not people who have already obtained their visas or their permanent resident status through lawful processes. It is extremely important to emphasize that existing visas are not automatically revoked by this travel ban. If a traveler holds a valid visa issued before the ban's effective date and meets all other entry requirements under immigration law, they can generally still use that visa to enter the United States. The ban does not reach back in time and cancel documentation that was lawfully issued before the restrictions took effect. This is one of the most misunderstood aspects of the policy, and the failure to understand this distinction has caused unnecessary panic among visa holders who believed their existing visas were suddenly invalid. A key point to understand that has been lost in much of the alarming coverage spreading across social media is that the ban does not apply to individuals already inside the United States. If you are physically present in America right now on any lawful status, the travel ban does not change your status or your rights while you remain in the country. Your situation is governed by the terms of your current status, not by the travel ban restrictions that apply to people seeking to enter. Lawful permanent residents, commonly known as green card holders, are not stripped of their status simply because of the travel ban. This is an extremely important clarification because many green card holders have been terrified by social media posts and videos suggesting their permanent resident status is somehow in jeopardy or that they will not be allowed to return if they travel abroad. Green card status remains valid under the law, and holders generally retain the right to re-enter the U.S. if they maintain proper documentation, carry their valid green card, and comply with all immigration rules that have always applied to permanent residents. The expanded ban covers both immigrant and non-immigrant visas for nationals of certain designated countries, creating a comprehensive restriction that affects multiple pathways to the United States. In practice, this has meant that individuals from designated nations who are planning to come to the U.S. to live, work, study, or visit must now meet much stricter eligibility criteria than they would have faced before the ban took effect. They must apply at U.S. embassies or consulates that are equipped to handle the restrictions and the enhanced security protocols that come with them. And they must navigate enhanced security reviews that can add significant time and uncertainty to their applications, including additional background checks and vetting procedures. Almost simultaneously with the expanded travel ban, the U.S. State Department issued a separate order on January 14, 2026, to pause immigrant visa issuance for citizens of 75 countries. This action is distinct from the travel ban itself, though the two policies overlap in significant ways and have created additional confusion among applicants who are trying to understand which restrictions apply to their specific situations. This visa pause is part of an ongoing evaluation of screening procedures and public charge grounds of inadmissibility, and it means that consular posts worldwide have been instructed to halt the issuance of new immigrant visas to nationals of those 75 countries until further notice from the State Department. Under this directive, individuals from these 75 countries appear to still be able to submit visa applications through the normal channels and attend interview appointments at U.S. embassies and consulates around the world. The application process itself has not been suspended, and people can still file their paperwork and attend their scheduled interviews. However, consular officers are instructed not to issue immigrant visas while the pause is in place, meaning that even applicants who complete successful interviews and provide all required documentation may find their cases held in administrative processing indefinitely until the pause is lifted and visa issuance resumes. This pause affects both family-based and employment-based visa applicants who are outside the United States and processing their cases through consular channels rather than adjusting status inside the country. Families waiting to reunite, workers waiting to begin employment, and other immigrant visa applicants are all affected by this temporary suspension, which has no announced end date and could continue for an extended period depending on when the administration completes its policy review. To be absolutely clear about what this means in practical terms, this visa pause applies only to immigrant visas, meaning green card applications that are being processed through U.S. embassies abroad through what is known as consular processing. It does not apply to non-immigrant visas, such as tourist visas in the B1 and B2 categories, student visas in the F and M categories, or certain work visas like the H-1B, which continue to be processed based on standard procedures unless otherwise restricted by separate rules or by the travel ban itself. This means that while immigrant visa processing is restricted for these 75 countries, temporary visitors and workers from those same countries may still receive non-immigrant visas and travel to the U.S. under appropriate categories, provided they are eligible under the specific visa requirements and meet all other entry criteria. The system has not shut down entirely for nationals of these countries. Rather, specific categories of visas, specifically immigrant visas, have been paused while other categories continue to function more or less normally depending on the specific circumstances. There is broad overlap between the expanded travel ban list and the countries affected by the immigrant visa suspension, but they are not identical lists, which adds another layer of complexity for applicants trying to understand their situations. The expanded travel ban includes restrictions based on national security assessments and applies to visa issuance or admission for designated countries based on criteria related to terrorism concerns, document security, and information sharing arrangements with the United States government. Meanwhile, the immigrant visa suspension focuses on a broader set of 75 countries identified by the State Department for a pause in visa issuance pending policy review of screening procedures and public charge determinations that assess whether applicants are likely to become dependent on government benefits. Now, let us talk about what this means for green card holders and existing visa holders, because this is where the most significant confusion and fear has developed in recent weeks across immigrant communities. As we have already noted, green card holders who already have valid permanent residency are broadly exempt from the entry restrictions of the expanded travel ban. This means they can still travel to the United States and re-enter the country as long as they carry valid documentation, including their unexpired green card and a valid passport, and satisfy standard entry requirements that have always applied to returning permanent residents. Exceptions to this general protection for green card holders are rare and typically require specific legal issues that are unrelated to the travel ban itself. For example, a green card holder who has been convicted of certain serious crimes, who has abandoned their U.S. residence by living abroad for extended periods without proper documentation like a re-entry permit, or who has other grounds of inadmissibility might face issues at the border. However, those issues would exist regardless of any travel ban and are not created by the current restrictions. Similarly, individuals who already hold valid visas, whether immigrant or non-immigrant, generally retain the right to enter the U.S. on that visa as long as it has not expired, and they meet all admissibility requirements. The travel ban does not automatically invalidate existing visa stamps in your passport. If you received a valid visa before the restrictions took effect and that visa has not expired, you generally retain the right to use that visa to seek admission to the United States, though final admission decisions are always made by border officers at the port of entry. However, those existing visas may still be subject to individual refusal at the port of entry if border officials determine the traveler does not meet admissibility criteria on the day they seek entry, just as they would under normal immigration law, even without any travel ban in effect. Visa holders should carry complete documentation and be prepared to answer questions about their travel purpose and admissibility, as they always should when entering the United States. For visa applicants currently outside the United States who do not yet hold valid documentation, the new restrictions present real and significant challenges that should not be minimized or dismissed. If you are from one of the designated countries covered by the travel ban and you do not hold a valid visa as of January 1, 2026, you may face enhanced screening requirements, longer processing times, and possible denial of visa issuance until policy exceptions or waivers are clarified by the State Department. The path to obtaining a visa has become significantly more difficult for nationals of affected countries, though not necessarily impossible in all cases. Similarly, if you are from one of the 75 countries subject to the immigrant visa suspension, your case may not move forward to final visa issuance until the temporary pause is lifted, even if you have already completed your interview successfully and provided all required documentation. This creates a frustrating and uncertain limbo for applicants who have done everything right and followed every rule, but find their cases stuck in administrative hold due to policy decisions completely outside their control. For families and workers waiting on immigrant visa processing, this means planning cautiously and maintaining realistic expectations about timelines that may extend well beyond what you originally anticipated. If your priority is to reunite with family members or begin employment based on a newly approved immigrant petition, you should remain in close contact with your attorney if you have one and monitor embassy announcements and State Department guidance regularly for any changes to the pause. Keep your documents updated and current, including medical examinations that may expire if not used within certain timeframes, financial documents that need to remain recent, and any other evidence that might need to be refreshed while you wait. And be prepared to demonstrate strong financial circumstances, clean background, and clear admissibility whenever interviews are rescheduled or policy updates are issued that allow processing to resume. Another layer of complexity affecting visa applicants in the current environment is the administration's use of the public charge ground of inadmissibility, which has been invoked in recent policy guidance and has influenced decisions about who may be deemed eligible for visa issuance from certain countries. While public charge determinations have long been part of U.S. immigration law going back many decades, the current policy environment places added emphasis on financial self-sufficiency and long-term independence from public benefits when evaluating visa applications. Public charge considerations do not apply to green card holders returning to the U.S. after travel abroad, so permanent residents should not be concerned about this issue when they travel. However, public charge grounds may significantly affect visa applicants abroad if consular officers determine that a candidate is likely to require public support after admission to the United States. This can further complicate immigrant visa issuance in the current policy climate, particularly for applicants from countries with lower average incomes, for applicants who do not have strong financial sponsors in the United States, or for applicants whose personal circumstances suggest potential reliance on government assistance. Some immigration experts and advocacy organizations have pointed out that these pauses and bans will likely lead to long-term declines in legal immigration numbers, potentially reducing overall immigrant admissions by a significant percentage over the next few years, depending on how long the restrictions remain in place and whether they are expanded, modified, or eventually lifted. These are legitimate concerns that deserve attention and ongoing monitoring as the policy environment continues to evolve. At the same time, it is important to balance these concerns with realistic context about what the restrictions actually do and do not accomplish. Travel bans and visa suspensions do not eliminate pathways for immigration entirely. They restrict those pathways and add layers of review, but they do not close the doors completely in most cases. Lawful permanent residents continue to live in and re-enter the U.S. under their valid status with relatively few complications in most situations. Many non-immigrant visas continue to be issued when eligibility is demonstrated under the applicable criteria, and temporary policy measures can be modified or rescinded over time based on legal challenges in the courts, administrative revisions by the agencies, changes in the political environment, or new executive actions that supersede current policies. If you are a green card holder or a current visa holder, the most important thing right now is to stay informed through reliable official sources, maintain your documentation in proper order, and consult a qualified immigration attorney if your case involves complex eligibility issues. This is particularly important if you have concerns about public charge grounds, prior immigration violations that might affect your admissibility, criminal history that could trigger bars to entry, long absences from the United States that might raise questions about whether you have abandoned your permanent residence, or any other complications in your immigration history. What we are seeing in January 2026 is a period of expanded travel restrictions and temporary visa suspensions designed to increase screening and vetting, especially for immigrant visas from certain countries. This is not a blanket ban on all lawful immigration to the United States, despite what some alarming headlines and viral videos might suggest. The details matter tremendously, and understanding how existing rules interact with new proclamations is essential for anyone navigating U.S. immigration this year. We strongly encourage everyone affected by these policies to avoid making major decisions based solely on social media posts, forwarded messages, or videos that prioritize alarming content over accurate information. Verify everything through official sources including the State Department website, USCIS announcements, and guidance from the specific embassy or consulate handling your case. When in doubt, consult with a licensed immigration attorney who can evaluate your specific situation and provide guidance tailored to your individual circumstances. We will continue to track official announcements and policy changes as they develop and explain what they mean for green card holders, visa applicants, and families around the world in clear and accessible terms. Immigration law is complex and constantly changing, but accurate information is the best tool you have for protecting yourself and your family during uncertain times. Stay calm, stay informed, verify what you hear before acting on it, and do not let fear drive decisions that should be made based on facts and careful analysis of your specific situation. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas, such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info Channel. Thank you for watching, and we will see you in the next video.